Morning, good afternoon or good evening. Welcome back to the Law Vlog, episode 23. So in this vlog I want to discuss two legal areas involved in any litigation case. The first one, we had a person injury road traffic accident type case brought to court about 2 weeks ago. Our client was driving a vehicle, stopped at a T-junction, about to turn right, and someone came into the back of her, crashed into her rear end. But the other side used a defence known as the minimal impact defence. So basically what they are saying is that the speed at which their car was travelling and the velocity of the impact and the impact itself could not have caused the injuries our client sustained. This is a very common defence where an insurance company or the solicitor for an insurance company would use to defend their claim. Get me over there. Sure. So I'm going to go through that defence in detail here. So this happens a lot in road traffic accidents when there's considered a low impact. So our client was rear-ended by a car. Our client was at a T-junction and the car struck the back of our client's vehicle. The other side are saying that the injuries our client sustained could not have occurred due to the speed of the car that was travelling. So I refer to an article written by two solicitor colleagues in Beale & Co. Law firm where they discuss the defence of minimal impact in detail. I'll share the article here. And just going to the conclusion there, the decision of both the High Court and Circuit Court of Appeal in this Dunphy case relays in a series of recently published and reported decisions in which the courts have not been persuaded to the view that the absence of any significant material damage to a claimant's vehicle is in and of itself a reliable indicator as to the likelihood or possibility of injury to the occupants of a vehicle and the level of severity of such injuries. So basically what this case is saying is that just because there was low impact and very little damage done to the plaintiff's car, this is not indicative of any injury that may be caused from said accident, nor is it also indicative of any liability, or it should be the case that liability should be attributed to the defendant even if they're travelling their car at such low speed. Indeed, also in my own case that we ran a few weeks ago and were successful, our engineer, which I will share a paragraph here from his report. I'll actually share the report here and I'll paraphrase it somewhat. There's much debate these days in the courts and elsewhere about the issue of whiplash type injuries sustained in low speed rear impacts, and it is often suggested that if there was no damage to the vehicles involved in the collision there can be no injury. This of course is not true for two reasons. Firstly, the fenders of bumpers of modern cars have a fair degree of flexibility which allows them to absorb impacts without any damage or permanent deformation to them, and secondly there can be a wide variation in the stiffness of the fenders. I also want to share this last paragraph from our own engineer report dealing with acceleration. In a rear-end collision what occurs is the speed of the target or front vehicle is suddenly accelerated to approximately the same speed as the bullet or rear vehicle over a short time span of a fraction of a second, and it is this very high rate of acceleration that caused the whiplash effect between the torso and the head of the occupants of the front of the vehicle. I'll share the rest of the paragraph there as well, but as you can see, a minimal impact defence, while it's proven for a defendant to use that in their case, it's not always successful. So thank you very much for watching this week's vlog. I hope it's been informative to you. We were back next week with a couple podcasts lined up, so this Swedish Show Lawyer podcast is back. Until then, have a great week.